Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I am Judge Eric Eisnagel from Orange County. To my right is Judge Wendy Berger, and to my left is Judge Renee Roche. She is visiting us also from Orange County there. Please make sure that you turn off your electronic devices, cell phones, or silence them so that we don't interrupt the advocates today. And as if you're the appellant, when you approach, if you could please let me know how much time you'd like to have in rebuttal, and I will do my best to accommodate you in that regard. We now have, for both civil and criminal cases, we allow 20 minutes on each side. And so all the cases today will receive 20 minutes on each side. And with that, we will begin. The first case on the docket is DUSTIN PURDEE versus State of Florida, 1734-58. And counsel, if you could just let me know how much time you'd like in rebuttal.
May it please the court, Anthony Candela on behalf of DUSTIN PURDEE. I'd like to save approximately 4 minutes for rebuttal.
Okay, counsel, whenever you're ready.
Your Honors, this is an appeal from a trial case involving a charge of aggravated child abuse in which the jury at the end of the trial returned a verdict for the lesser included of felony battery. After the trial, Mr. Purdee was sentenced, and his counsel at the time stipulated to a prison releasee reoffender sentence, and Mr. Purdee was sentenced to 5 years.
And you contest the fact that he qualified as a prison releasee reoffender, correct?
Yes, I did.
And I mean, I realize that felony battery is not an enumerated crime for that offense, but why wouldn't it fall into the catch-all qualifier as crimes of violence?
Well, and that's one of the main issues in my appeal, Your Honor. That is the second issue that I outlined. The situation is that in this case, the child designated by the initials DD was injured in some fashion. It's the appellant's position that that was a circumstantial evidence case in which the child the night before was relatively fine, according to the testimony.
I realize that's being a circumstantial evidence case in your first issue, but as to regard to the PRR status, why wouldn't felony battery qualify based on the fact that under the catch-all provision?
Well, two reasons, Your Honor. First, because felony battery has a "or" as the conjunctive between touch or strike, it is been the predominant view across the state, both in this circuit or this district and in others, that touching is not an act of violence.
I get it. Simple battery would probably not, because there's not a serious bodily harm element to simple battery or battery on a law enforcement officer. I mean, you don't know in those situations that there's been bodily harm. Whereas on felony battery, it's a different story based on the elements of the offense, correct?
Well, yes, but I would liken to a civil concept, Your Honor, like the eggshell-skulled plaintiff. If I push you and you bruise easily because you have some...
But the evidence in this case wasn't that the child had a simple bruise. The evidence was that the child had 2 broken arms at the shoulder, as well as other bruising, and was in the hospital for multiple days.
Correct, but that goes back to the circumstantial aspect of the case in which the...
Well, I'm talking about specifically the bodily harm or the bodily injury in this case, because felony battery is a touching or striking and causes great bodily harm, permanent disability, or permanent disfigurement. And so I don't think there's any circumstantial evidence based of the harm that this child received.
Right, Your Honor, but that's the part of the problem with this case. It's a touch or strike. If I put my hand on you and push you down a flight of stairs, there's no violence. I haven't struck you. I pushed you. I touched you. You ended up with multiple broken arms.
Wait, hold on.
Well, I think that's a jury
So touching someone and pushing them down the stairs is not violence?
Well, not in the sense of strike. Because the legislature was very clear on how they wrote this.
How about the
Touch or
sense?
strike.
How about the sense in touch causing great bodily harm?
Well, Your Honor, if I have something in my hand.
Well, I think the question is it violence? I mean, you just gave us the analogy, right? The fact pattern, you touch someone and push them down the stairs, and you said that's not violence. Can you explain that statement to me?
I can, and I go back to, I think I cited both in my brief, my initial brief, and my reply brief, going back to the Johnson case that the United States Supreme Court took up on our misdemeanor battery statute, that it would not qualify because of the touching aspect for armed career criminal, which requires a crime of violence to trigger the armed career criminal statute in the federal court. And if the touching aspect of our misdemeanor statute, which is the exact same elements, regardless of the result of the touch, is not going to be violence, then I'm not sure that we can say, well, because we add this other element where the person got injured in some fashion.
Except that the case law says that you do. Correct? I mean,
Correct,
you can't
but-
just look at it, and eliminate the other important element of a felony battery, that being the infliction of or the cause of serious bodily harm, great bodily injury. I mean, you're leaving that out, and you're asking us not to consider this as to what he was convicted of, which is felony battery as opposed to a misdemeanor battery.
Well,
How do we disregard the rest of that statute?
the problem with the catch-all phrase in the PRR statute is it leaves open for interpretation what may and may not fall within it.
But you didn't raise a constitutional challenge to that.
No, I did not raise a constitutional challenge because I'm arguing it doesn't fit within the definition. I'm saying that in this set of facts, that the injuries could have happened.
Counsel, all right, why don't we take a different approach on this? In order to fall into the catch-all, there has to be the use of or threat of physical force or violence.
Correct.
Give me an example of a touch that causes great bodily harm that would not involve the use of physical force or violence. Help me out.
Well, if you're saying violence.
No, I'm not saying it. The statute says it. Physical force or violence. Give me an example.
If you pick up a child, a newborn, and you hold them too tight, you could fracture their bones. You're touching them. You're not striking them. You're not using any violence.
That's not physical force? You keep saying violence and ignoring the physical force part.
Because I go back to touch or strike. Touch doesn't fit with violence, or doesn't fit with physical force. If I touch you,
Hold on. A touch that causes great bodily harm? Give me an example where there's no physical force or violence involved. I'm still looking for that example. A squeeze would certainly be physical force. Do you concede that?
Your Honor, but then if I shake your hand too hard, I could be charged with felony battery. That's absurd.
Did you break my hand?
If I broke your hand, but what if you have a condition in which your bones shatter?
Is it-
You're like that. You're like one of those people that has osteoporosis problems, and I shake your hand and it shatters. I've committed a felony battery. That's absurd.
Well, not if it would potentially be a felony battery if the other person didn't consent to you shaking their hand and put their hand out. Do you have a case in Florida that says that felony battery, based on, and I'm not talking about a felony battery where you have multiple misdemeanors that make it become a felony battery. Those aren't the facts we have here. But a felony battery where the felony battery is based on an intentional touch or strike causing great bodily harm, permanent disability, or permanent disfigurement, where the court has concluded that that does not qualify under the catch-all for the PRR statute.
Your Honor, if that's the situation, then the only case I'm aware of is the case out of the 2nd District.
That's Brooks v. State.
Brooks.
And Brooks held that it does fall under the catch-all provision.
Correct. But prior to Brooks, almost all the cases on this issue had come out of this district or the 1st.
But the Williams Court out of the 4th District Court of Appeal, which was prior to Brooks, also held the same, correct?
I believe Williams was slightly different. Brooks was a straight felony battery in which the 2nd District said, yes, there is an element of.
But both of those said that a felony battery, where you have an intentional touching or striking causing great bodily harm, that both of those that felony battery qualified under the catch-all provision of the PRR statute.
Yes.
Okay.
Okay. However, I think that these are because you're falling into the catch-all provision, I think it's fact-driven.
Okay,
We're
well,
not
we have a child in this case that was severely injured. So let's go back to your circumstantial evidence on the conviction.
We say severely injured. The testimony was, put aside the emotional aspect, it was a Salter II fracture. That's the most common fracture that a child can have.
Well, was that evidence brought forward
Yes.
during trial?
Yes, that was. The Salter II testimony was the abundance of the medical expert's testimony. He opined that it had to become of torsion. However, there is plenty of literature and common knowledge from people to know
The
that.
testimony was also that this fracture, the double fracture on this child's arm, both of his arms at the shoulder, was highly unusual and not where you would typically see that type of fracture.
Correct, Your Honor. And those are the facts before the court. I can't change those. But what I can tell you is that a Salter II fracture is, according to the literature, the most common fracture that a child could have. So,
Well, it sounds like there was
Not in this
conflicting
location.
evidence on this point, counsel.
yes, Your Honor.
Okay.
So, but to go back to Judge Berger's point, because it's an injury and it's a child, we can't all of a sudden just go, well, then it has to be violence. There could have been several different ways of getting there. I'm just.
But there was evidence from which the finder of fact could have concluded it was violence.
Correct, but the finder of fact also didn't conclude that this was aggravated child abuse, nor did they conclude that this was child abuse. So the finder of fact is disregarding that DD is a juvenile in some fashion. I mean, the problem with this, and I outlined this in the reply brief, is we're dealing with two-level lessers from what was actually charged. So the jury DD was clearly a juvenile, and the jury disregarded that.
Well, they clearly believe that the child suffered great bodily harm, permanent disfigurement, or permanent disability.
But they must have believed that he wasn't a child, because how do you come back with felony battery?
We don't need to go second guess. I think jurors do what they do. But the point of the fact is that you have an element of great bodily harm, and you can look at the jury verdict and determine that they believed that this child suffered some serious harm. And I don't think that, I mean, the evidence certainly supports that. Now, the evidence could support that this happened a different way as well. But if you have a conflict in the evidence and it could go one way or the other way, how is it that the trial court, especially in light of the fact that your client told the law enforcement officer to describe striking the child in punishment. So with your client's admission that, not that he did this damage to the child, but he was describing how he was holding the child kicked him, and so he disciplined the child by spanking the child. I mean, so you have the defendant in this case admitting to some level of corporal punishment. You have a severely injured child. Isn't that a jury question on whether or not your client was the one who inflicted this injury on the child? Yes. And if it is, how did the judge err in denying the motion for judgment of acquittal?
To the judgment of acquittal argument, Your Honor, I believe that the testimony was what happened, and the child, or who hurt you, or how did you get hurt, and all he said was DUSTIN, meaning the defendant.
Right.
There's nothing criminal. You could get hurt in many ways around a child. It doesn't necessarily mean that was a criminal act. You have to prove a crime. The facts matter, and the level of proof matters. The child just said, the child was even more crazy. It was a leading question to the child because the child wasn't answering. So at that point, I don't think that the state should get the benefit of asking a leading question as to develop what happened.
Was there an objection?
There was not an objection.
Okay.
Well,
then-
and that's not what the nurse testified to. There wasn't a leading question that led to that answer when he said, "Dustin hurt me with his hands."
That was child hearsay, and there was
There was
again,
no objection.
And I fully admit that there was no objection, and I can't go back. I don't have a DeLorean to go back and get the trial counsel to object to the child hearsay. There wasn't any. So I'm stuck with the statements that the nurse practitioner made that DD said.
Well, I just want to make it clear, too, that there's nothing in this record that suggests that the nurse asked leading questions, put some situation in the child's mind that caused him to answer in a certain way. It was an open question, and the child didn't just say, Dustin hurt me with his hands.
I think we're talking about two different things, Judge Roach. I think you're talking about the nurse practitioner's testimony. I'm talking about the live child that came to court. Dee Dee testified and would not speak. So,
Right, but it's still in the record, it's still evidence. The nurse's testimony about what the child told her, to which there was no objection.
to which there was no objection, and that may be a 3850 issue for a different day.
It's not for us.
Correct. However, that evidence came in about what she said that that the child said. So I can't argue that. However, I can say that you start stacking evidentiary things that we've added into the code to prove your case, instead of the child saying, I was injured.
You have a child that was injured, without question. The child had 2 broken arms at the shoulder. That's without question.
Yes, ma'am.
You have the child testifying, Dustin, meaning the defendant, hurt him at trial.
Yes.
You have the doctor's testimony that the unusual nature, the doctor's opinion that this was an inflicted injury upon the child. You have the child hearsay testimony that came in. You don't think that's enough for it to go to a jury?
But here's the problem, Your Honor.
And you have the defendant's testimony that he struck the child.
We're left with felony battery. That, when it went to the jury, was aggravated child abuse.
Correct. And you think that,
that's the problem here, is a JOA argument deals with.
of course, it's going to deal with the crime that's charged, which is aggravated battery.
Correct.
I mean, and on a child. And so you have that. So you're saying there was enough to get past the JOA on that?
But not for what he was convicted of, because what he's convicted of says touch or strike. And
well, he was touched or struck. I mean, a lesser included offense incorporates all of the elements of the offense, the main crime charged.
Yes, that's correct. However, putting aside the child hearsay, I think that what the evidence was there's injuries, and the person said, and the child at trial said, when they asked him a leading question,
He did it.
He said, Dustin. What does that mean? Isn't the state's job to prove beyond a reasonable doubt what happened, not just to leave it in some lurch and say, oh, here, jury, go figure it out?
Well, that's not the standard at the JOA, whether or not the case has been proven beyond a reasonable doubt. If you look at all the evidence in the light most favorable to the state, and is there enough evidence to have it go to the jury to decide?
I don't think there was a prima facie case that a crime occurred.
Counsel, you're into your 4-minute rebuttal.
If I may reserve, Your Honor.
May it please the court, I'm Carmen Corrente with the Attorney General's office. Just want to point out, as far as the Salter fracture, the most common fracture for children over 10 years old, not a 4-year-old child at the time this happened. We have testimony from Dr. Michael Bell, which answers all of the issues in this case. Dr. Michael Bell, as this court has already pointed out, but stated that this did not occur by touching. This was intentional infliction, reasonable degree of medical certainty that it was child abuse. That establishes corpus delicti. We have a crime. That also establishes that it's not, the felony battery, which then qualifies it for PRR. Just his testimony, he hadn't seen anything like that in 35 years of that kind of examinations. This is extreme injuries. There was a lot of pain. Also, the child, of course, was not screaming at pain about something that happened 2 days before. He was describing exactly what was done to him to hurt him that badly that he had to spend all that time in the hospital. They were asking him, how did this happen? Who hurt you? He did it. It was child abuse according to the doctor, so we have covered everything. It wasn't a circumstantial case either because the victim was identified. The perpetrator was identified. So I think that's all plain from this evidence. If the court has any questions for me, then I will ask you to affirm. Thank you.
Thank you, counsel. Okay, counsel, you have 3 minutes, 12 seconds.
Thank you, Your Honor. I would just go back to the PRR statute. I think this is debatable as to what, because it's the catch-all, you end up with a complete judgment call by the court. Because again, there was no specific finding. This was a lesser included offense. There was, when I say specific finding, I mean something like an Apprendi finding, which Apprendi doesn't apply to that, but something where they were asked to find a level of violence.
Well, you have counsel stipulating and defendants stipulating to being designated as a PRR. So unless it's just completely unlawful, why wouldn't that stipulation control? Because there's case law out there from the 2nd and the 4th District that say felony battery under these circumstances, not necessarily where there's great bodily harm, qualifies under the catch-all provision as a PRR if everything else is satisfied.
I don't know why the defense counsel stipulated. I think that, I don't know. I could venture some guesses. It was a lesser, Mr. Purdy was looking at 30 years and ended up with
5.
5, and thought maybe that was, super and I'm going to get out of here. Who knows? I don't know. That may be an issue for 3850, that or some other type of habeas. But you can't stipulate to
Well, people stipulate that they qualify all the time. The point is that in a case where you've stipulated and felony battery does qualify as under the catch-all for PRR, have you waived the issue?
potentially. To be fair to your question, potentially.
Right.
And that may be another issue. For instance, if this court was going to rule that it doesn't apply, but he stipulated, too bad, so sad, then that would be an issue for an ineffective assistance of counsel, because counsel shouldn't be stipulating to facts that damage his client. I know that it made it easy for the sentencing, but if the person's going to be PRR, how hard is it to get up there and have the state bring in the pen pack from prison to say, Mr. Purdee got out of prison within 3 years?
Well, there was the state was prepared to present the evidence, correct? And then they stipulated? Is that?
No, my understanding is the state didn't have any evidence, but we never got to that question. We don't know that answer.
Okay.
I wish I did, because that may change.
The state had no evidence of PRR, is that what you're saying?
The record doesn't reflect that they do or they don't, Your Honor. So I have no idea if they had a pen pack. I don't know if they were prepared to I don't know if Mr. Purdee's fingerprints were rolled. There's none of that in the record.
Is that what you mean when you say the defense counsel stipulated the facts?
Judge, what the record, and I only have like 5 seconds, but what the record reflects is that they walked into court, the sentencing hearing was very quick, and the defense stipulated to the PRR.
PRR, okay.
But I don't know what that means. Does that mean that he qualified? Does that mean that we agree to the sentence? I have no idea.
Thank you, counsel.
Thank you.
Okay.
Go ahead.
I was just going to say that my review indicates that the state advised the court that the defendant qualified as a PRR and that it had witnesses there to establish that, but then there was an agreement.
And that may be, I don't know what again, we don't know what that means. Other than I have witnesses, I don't know if
I think
he
it takes
qualifies.
rocket science. Okay.
Thank you, counsel. Thank you.